All right, today's video we're going to go over today is how to invest in an IRA outside of the market. You want to take control of your IRA and you want to invest outside the market. How do you do this? What needs to get done? These are called self-directed IRAs, IRA LLCs, checkbook control IRAs. These are all names for different concepts. But I think this is going to be very important coming up here very soon when the stock market crashes, because eventually reality has to hit everything. And the reality is the U.S. economy is tanking. And so you need to get into more solid investments, which are going to be the main ones, which is fixed things like land and real estate. Okay. All right. Before I ever get started anything, I'm a person who loves to see the whole forest before you show me a tree. And so right here, we're going to get a 10,000 foot view. What is the rules about investing my own IRA? Okay, what can I do? What can I do? First off, the first rule that you need to know, there are prohibited transactions with disqualified person, with a disqualified person or persons. Number two, prohibited to personally benefit. It should be prohibited to personally benefit from a disqualified person. So a disqualified person, which we'll get to and define later on in the video, cannot personally benefit. And the last is there are prohibited investments, in which we're going to start off on the last. Oh my goodness, let's go back into there. Sorry guys, we lost that for a second. I must have hit something on my thing. So IRA prohibited investments. First off, life insurance contracts on IRA owners. Well, I'm not going to get into it. There is ways to invest in life insurance policies, just not what most people want to do. Collectibles like coins, artwork, gold, silver, but you can buy precious metals. There's a way to do this. An S corporation stock. S corps are usually personal corporations that you are working. You don't want to get involved in that. Best thing to know about the prohibited investments is stick to the things that other people are doing with their IRAs. Now, it's an easy way to visualize it. I like this this little visualization that someone did. Basically, stock, bonds, mutual funds, ETF. Okay, that's easy. That's if you generally go get a self-directed IRA, you can go invest in those easy with no problem. That's just doing what other advisors do, and this is what most places that are letting you do self-directed IRAs are letting you go do. However, this is where we want to get to. We want to get outside of the stock market. It gets more complex because we have all these rules. It's hard to buy a stock and violate one of these rules. And so that's where we're going to get to in here. And then we have the prohibited investments that I just talked about. What is not a prohibited investment? Real estate. Ooh, that's nice. I like investing in real estate. That's where I made all my money. Privately held C Corp stocks, LLC membership interest, and limited partnership interest. You can invest in those. Okay, that's a good idea. Prohibited transaction rule. Section 4975 of the IRC, the Internal Revenue Code, prohibits certain transaction between an IRA and a disqualified person. So let's get back to this. Prohibited transaction. So doing business, the transaction. Who is on the other side? You're not prohibited from doing a transaction. You are prohibited from doing it with a certain person. And that's key to keep in your brain. Okay, who can I do business with? Who can I not do business with? So let's go down here. Well, first off, what's the punishment? You're going to go to jail if you screw this up? No. Your IRA is just deemed to be a taxable income. So whatever you have in that IRA now is income to you, and you have to pay a bunch of taxes. Plus, if you're under 59.5, you have to pay your 10% penalty. Okay? So that could be a huge hit in 1 year if you put a ton of money in your IRA. Who is a disqualified person? You can't do business with yourself. You can't do a transaction. You can't buy your own home or something like that. Your spouse, your parents and grandparents, your children and grandchildren, spouse of your children and grandchildren, your IRA trustee or custodian, your attorney, etc. That etc. is very important. That scares people. All right. So let's visualize this. Okay, so we have these orange. This is a nice visualization someone did. So we got these orange people that are a no-no. But look, who's okay? Aunts and uncles, cousins, brothers and sisters. Because these are the people you don't like anyway. So the government's like, fine, go ahead, do whatever you want. We don't care if you want to deal with those people. Your spouse's parents. That's interesting, huh? There's another visualization if you like something that's simpler. All right, okay, this interest, they do a really good job putting a bunch of information out. But it's so simple that they kind of go everyone else here, and it's like, really? Everyone else? So what about an LLC owned by these people? Well, we get to that. The disqualified person rule, an entity with 50% or more ownership of these people, okay? So you form an LLC, and we're going to get into this in just a little bit, because what I want to do here is I'm going to go over the general idea and concepts, and if you're going to notice, this video is going to be really long, because I'm going to jump into a case, and I'm going to explain where you can kind of get off this video. You don't need to watch it anymore to know what you need to know. But if you want to get into case law, I'll go through case law with you, because I love case law, because as an attorney, that's where you get peer reviewed. So it's like going through a peer review article. Okay. A 10% ownership of officers, director, and highly compensated employees of such entity. Okay, so that is another disqualified group of people. So as you can see, the IRS kind of figured out people trying to be clever with this and trying to, get around the rules by doing different things. A trust with 50%. So I can't form a trust and then have the trust own everything and then do business with my family and stuff like that. Any persons providing services to the IRA, taxpayer on the to the IRA, or myself. I'm an attorney. I'm a fiduciary, and if I form this LLC for you, I can also be involved in it. Brothers, sisters, aunts, and uncles are not disqualified persons. That's good to know. All right, let's jump in here. Now let's get to these. What's the transaction that is prohibited with a disqualified person? You can't sell, exchange, or lease property to a disqualified person. You can't lend money to a disqualified person. You can't furnish goods or services to a disqualified person. Transfer used by the disqualified as income or asset. You can't give it to somebody else and go, oh, here, I'm going to buy a house, and then you rent it out to somebody else. Oh, okay, so you can't buy a house, give it to your son to rent out to somebody else. Personal benefit and conflict of interest. Now, that just got me thinking, could I rent to somebody that's subleased from my own kid? I don't know. Of course you can't, because I'm trying to get around the rule. Okay, personal benefit / conflict of interest prohibited transaction. Indirect use of IRA income or asset for personal benefit. So you somehow personally benefit in an indirect way, some way around, like you lease to somebody that subleases to you. Receipt of any consideration by a disqualified person who's a fiduciary for his own account from any party dealing with the IRA in connection with transaction involving income or assets of the IRA. So you got to be careful of the fiduciaries that you have, like your CPA, your attorney, the people that you use to create this stuff. Okay, another prohibited transaction. So once again, you're thinking, okay, all these ideas that people have tried to come up with to come around the rule. So what about this idea and so we call this the plan asset rules, okay? Plan asset rules, if 100% of the operating company is owned by one or more IRAs or disqualified persons, assets of the company are deemed IRA assets. So this comes into a big thing. So a lot of people think, well, what if I invested my money, and let's say I just invested $10,000 to get my business going, and then my business gets going, and it's generating its own income. Is the income that it generates, is that going to be, are those disqualified? Can I pay myself from that money? That's a great question, and we're going to get into that. And the answer to that question is they deem them all the IRA's assets, okay? And this gets really hard because IRA sounds a lot like IRS. So a lot of times when I'm reading through these things, I might say IRS assets. a slip up if I do that. Okay, 10 people use the IRA to buy real estate together. This is kind of an example. Okay, so we get 10 people together. So one guy's investing his own money. Okay, how do we deem what money's IRA money, what's not IRA money? And we're going to say all of it is. If 25% of the investment company is owned by one or more IRAs and disqualified person assets of the company are deemed IRA assets, okay? That's important to understand. In determining whether the threshold is met, all IRAs are considered, even if owned by unrelated individuals. Wow, okay. So we can have unrelated and then all the assets be deemed. So what is an operating company? It's an entity engaged in production of sales of product or services other than investment of capital. Okay, so it's not an investment advisory. It's okay. This includes a real estate operating companies where at least 50% of the assets are invested in real estate. It's important to understand what could become IRA asset money. What happens if assets are under plan asset rule? All assets of the entity are deemed owned by the IRA. So we're gonna exclude. And when I get to my case that I'm going to go through here, this is important to understand because an individual invests in a business and then he claims that the business made money and that's how he got paid, that he was working. Okay. Transactions between entities and disqualifiers can be a prohibited transaction. Example, Kelly IRA owns 100% of Kelly Belly Inc. Kelly Belly makes a loan to Kelly's mother. Loan is direct prohibited transactions. This loan is deemed made by the IRA. Okay. So we loan the money to the IRA does this transaction. So the checkbook control rule is, so the idea you got to get in your mind is, okay, so self-directed IRAs traditionally are understood as you're going to have your own account, you're going to go do your own investing, but it's really held at a financial institution. So it's kind of like just a normal IRA, but you're directing the investments. But what if I want to start my own company and I control the purse? So what is that? So traditional, I just explained that, but let's go to checkbook controlled. Trust company holds IRA money, attorney creates LLC, your IRA is the sole member and you are the manager. The LLC sets up checking account. Trust company capitalizes LLC. LLC cannot have any other owners. We're going to get to that rule. LLC pays expenses and distributes all the income to the trust company. Okay, all right. So you get to control all the money and you get to go invest in more properties if you do this right. Potential problems. You got to pay your attorney to set everything up. I can't get paid directly from the IRA. You got to pay me through your personal money. Oh, that sucks. You cannot pay yourself a management fee because you're a disqualified person. You got to keep it all in the IRA. You cannot make loans to a disqualified person. Okay. You cannot rent to a disqualified person. Yeah, that's a problem. So I want to buy my kid's house, use my IRA, buy my kid's house, and rent to them. Nope. You get paid from another company which your own, which IRA also invests in. I don't know what I was trying to get with that. You get paid from another company. You own, which IRA? Okay, that's supposed to be you own. Alrighty. Okay, you can't do that, and we'll get to that a little bit later too. Okay, so that's the general idea. We're going to get a little bit more. So you might have been on the internet reading about what are called rollovers as business startups. So this is different. This is, you actually do want to invest in a company that you are going to run, but you want to get paid from that company because this is a startup business. Can you do this? And some really smart people have come up with this ROBS concept. If you create a C Corp, your C Corp adopts a 401k plan. The plan allows 100% of its assets to be invested in an employer stock. Roll over the IRA to a 401k plan. The 401k plan invests in your C Corp. Stephen, other employees can participate in the plan. So I guess I was going to call this, this should be really you. You and the other employees can participate in the plan. So this was the kind, and it seems to not violate any rules. But there's no case on this that I know of right now. So that means it's not peer reviewed. In the legal world, when you don't have case law, You have no peer review. You have no idea if this is actually a legitimate way of doing business because there's no court that said, yeah, you can do it this way. So you always have to be careful with ideas like this because you're taking the risk that you might be the case study. How to set up a self-directed IRA. Okay, you take your money and you establish and fund an IRA account. So we take it, we go to some kind of trust company, we establish the account, and you take this and you transfer from your prior IRA 401k to a self-directed IRA custodian. Okay, so we find that trust company. Then number 2, it buys shares of an LLC. This LLC cannot have any previous owners. It's very important. We'll get to that in a little bit. You manage it. It's this brand new IRA LLC, and we're going to get to, you have to do this all at one time. You can't do this at multiple times. Then you get to keep the the expenses and the income all get to transact in this investment, whatever it may be. Maybe you want to invest in precious metals. You want to do tax liens, real estate, whatever it may be. All right. So stopping there, I just basically give you a basic understanding of self-directed IRAs, how they work. What you need is you're going to need an attorney to help you set up your LLC. And then you need, on the second part, some kind of trust company, some IRA, Kingdom Trust, InTrust, all these different places. They will custody your money and help you set this up. But and understand there's fees associated with all this. So it's going to be expensive to kind of set this up. Not super expensive, but it's going to cost. But you generally get the understanding. You just need to hire people that are professionals that know what they're doing. Just don't do this on your own and you'll be just fine. And do what other people do. Don't try to be a maverick here. Just follow everything. If not, you might end up having a huge tax. Now, if you want to get off, you can leave. But if you want to ever be like a lawyer, well, this is your opportunity. This is what lawyers do. We read the cases because we want to know what's really going on. So this is the Ellis case. Mistakes we'll dive into. Terry Ellis forms a used car company with his IRA. Now, I'm going to explain the whole thing to you first, the mistakes that he makes. So as we're reading through, you're picking up on it. And so he starts this used car company, and he uses his IRA to invest in it. Okay. He has an operating agreement naming his IRA as members before IRA is created. He contributes a second amount after he contributes his first amount of $65,000 after 2 months. That's a mistake that he makes. He calls his company CST LLC, becomes a disqualified person upon initial capitalization. So I'll explain that, how that happens. Payment of compensation to Ellis as so he pays himself as a general manager. So that's wrong. He starts another business and he leases property to it, or he leases his lot from that company. And it was clearly set up as a disqualified person because because what he ends up doing is he puts his whole family in it, and this should be he was younger than 59 and a half, and so all of it was ordinary income to him in that year that he did this plus 10%, and we'll get to all that. Okay, so how does this happen? So let's go to the story. That's what cases are. They're stories, and then we go into the application. So on May 25th, 2005, a law firm helped this petitioner organize CST LLC. It's a Missouri limited liability. The operating agreement of CST, also dated May 25th, 2005, was signed by Mr. Ellis on behalf of First Trust Company of Onega FBO Terry Ellis IRA. That's how it's usually termed when the IRA account is set up with these trust companies. An entity that did not exist yet. Perfect. Done correctly. The law firm helped him out here. Did all this right. The agreement lists the original member as CST to be first. We're just going to call it First Trust as we go through here, owning 980,000 membership units. So now I'll see they refer to, instead of stock, you have membership units. And so he has 98% in exchange for the initial capital of $319,500, and a member not party to this action owning the remaining $20,000. Okay, so we have another person out there. We don't know who it is. They never tell us in this case. They own 2% of this company. All right, but since it's all done at the same time, there is no previous ownership, so you're okay. This is what happens, okay? All right, so we have this. I don't think I need an arrow there. I don't think that's a kind of weird arrow. But this is how the business is set up. We got CST, we got 980,000, we got 20,000 over here. It owns 98% too. We're good. We're good. We have it set up correctly. CST was formed to engage in the business of used vehicle sales. So he's a used car salesman. This company right here is going to sell used cars. Okay? At all relevant times during the tax year 2005 and 2006, Mr. Ellis was the general manager of CST and in addition worked at the company in its used car business. Now, whenever you're reading a case, usually every sentence has a reason it was put there. That's why lawyers sometimes make bad writers, because they're like, well, why would I put that sentence in there? It has no point to this book. Well, in case law, everything you read has a point. Why are they saying this? On or about June 7th, 2005. So we formed it back on the May 25th. Now it's June 7th. Mr. Ellis submitted an application to establish an IRA with First Trust Company. Okay. Oh, which we call First Trust. Yep, there we go. I knew they were going to eventually just call it First Trust. So the story continues. On or about June 22nd, so now we're about a couple weeks later, Mr. Ellis received a distribution of $254,000 from his 401k that he accumulated with his former employer, Avid Pharmaceuticals. Mr. Ellis took the distribution check from his I think that's wrong. That should not be in there. The 401k account and deposited the entire amount into his newly operated IRA. Okay? Remember, it was supposed to be $319,000, but we only have $254,000, so that's interesting. I wonder what happened. For some reason, maybe the IRA company didn't get him the money. And then on the next day, he had his company acquire not the full amount, okay, not all the membership interest, just part of the membership interest with the $254,000. First problem, you see the problem he did? So you're not supposed to, the business is not supposed to be owned by anything before, but he's going to be an owner. His IRA is going to be owner of this business when he makes the next distribution. So we have, this is what's going on. Visual representation. Once again, let me get rid of this green line because I have no idea what I was thinking when I was putting that in there. Maybe because I was just having fun making green arrows. Okay? So he doesn't buy the whole $980,000 is what he should have said. Okay? He bought only part of it. On or about August 19th. So we go almost 2 months later. He received an additional $67,000, maybe because he was retiring and that he was getting the rest of the money then. As with the first distribution check, Mr. Ellis deposited this entire amount. Oh, gosh, dang it. Now he made that second deposit into a business that was already previously owned. On or about August 23rd, Mr. Ellis caused his IRA to acquire another $200,000 in membership units in exchange for this $65,000. Now, he didn't put the whole amount in there. There's like $1,000 missing there. Wonder where that went. So he completed his $319,500 capital contribution. All right, and now he's like, I'm good to go. I initially said this is how much it is, but even though I made 2 distributions, it should be just fine, right? And so this is kind of a visualization of what happens. Once again, let's get rid of the green line there. All right, we got this an additional $67,000, and then he also gave $65,500 to CST. So it comes in, and he doesn't give the full amount. He only gives $65,000. All right, I wonder where that $1,000 went. I bet you used to pay a fee somewhere. I'm going to find that out later. On or about November 28, 2009, First Trust, the custodian of Mr. Ellis's IRA, requested a current estimate of the fair market value of the IRA membership interest in CST. On December 20th, Mr. Ellis provides a current valuation of CST to the IRA custodian. All right, and it goes into here, and I made a nice, handy visualization for you what happens here. They come in and they say, hey, we still have this $1,000 in here, and there was this initial contribution, so we're going to say it's worth $321,000. That's what this IRA is worth, which was not everything given to CST, but that's what they're going to say this 98% is worth. Okay. Alrighty. During the tax year of 2005, CST paid Mr. Ellis $9,754 as compensation as his role as general manager. That's what they reported on their taxes. I don't bet you made more than that. CST made these payments through checks issued from the corporate checking account. So it came from this bank account, not this bank account. All right? See what they were trying to do? They're saying, hey, we're good to go, because we're paying it from our corporate checking account and not from the custodial account. On March 15th, okay, so the next year, they file Form 1120 with U.S. Corporation Income Tax, so they file their taxes like they're supposed to on time. CST claimed a deduction from the corporate income for compensation paid to corporate officers. Okay, so he claimed the deduction. I got paid working, doing what I'm supposed to. Okay. And then there was an additional $8,900 for legal fees. Woo! Man, that attorney did good, charging a good amount of money. All right, so here we go. Once again, I don't know why I have my green line there. This is what happens. CST is the one that pays Mr. Ellis, not anybody else. Okay. On or about June 24th, 2005, Petitioner's Counsel, former firm, also organized, so we're going back in time. Fly back in time to back in the summer of 2005. They form another business called CDJ LLC. Okay? From that point to the date the parties executed the stipulation of facts, the members of CDJ were him, Mr. Ellis, 50%, his wife, 12.5%. Okay, and then Chris, Doug, and Jamie all own 12.5%. That makes 100% of the company. So we're good to go. So now this is what we have. Okay, this is the breakup of ownership. You get in the image in your house. We got CDJ and CST. CST's used car sales. CDJ, what does it do? Let's find out. I bet you it follows real estate. The purpose of CDJ was to acquire investment property and to rent such property through the issuance of commercial leases. Okay, so about 6 months later in December, CDJ acquires title to a parcel of land. Okay, right there. That's the address. Maybe we could go look it up and just see what it looks like. Well, let's do that. Why not have some little fun here? If we're going to be boring attorneys, blah, let's go here. Where are we? Boom. Is it still? Oh, here it is. There it is. Look at that nice beauty. Look at this business. Still run by him? Can we see a sign up somewhere? See any signs? Because you have to know this was done way after. Maybe zoom in here. Zoom in. Come on. Oh, there we are. Come on. I can't go in. Sorry, guys. Sorry. Thought that would be fun. But that's what it is. That's what we're looking at. Okay? Alrighty. So the purchase price for this, $142,000. So, like, if you're from California and you're watching this, you're like, what? Freaking look at that prime. Beautiful. Look at how beautiful that is for only 142. You come from here in the middle of the country, you would go, get better for $142,000 than that. I obtained a mortgage, so only $12,000 down. That's all that went in. Okay. All right. On or before April. No, notice we don't know where this 12 grand came from. Okay. We have no idea so far in our facts. That was good. At least I don't remember them saying anything. This return reported neither gross income nor receipt, but did report expense deduction of $3,598, resulting in a report net loss of that same amount. Okay, so we got here. Went off and bought this piece of property. All right. On or about May 6th. Okay, so now almost summer of 2006. We're still in the springtime. Petitioner filed a joint federal tax return. Okay, he claimed $75,000 of income, 76 wages. He has some losses here. And CDJ had some income to him too. All right. And then it goes in here, the petitioner did not report IRA purchased $98,000 of membership units from CST, okay? That's probably an important fact to clue you in that the IRS is not going to agree with Terry Ellis. Petitioner likewise did not disclose that CST and an entity that had paid compensation to Mr. Ellis in 2005 was thus owned primarily by his blah, 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 his IRA. His IRA owned it. It's a disqualified person, okay? So we got 77,000 losses, pension distribution of 321,000. That's what they're claiming was not taxable. Okay. Petitioner did not report that Mr. Ellis' IRA purchased a total of, we already read that. Okay. Petitioner likewise did not disclose CST, an entity that had been paid compensation to Mr. Ellis in 2005. Okay. So they didn't say, hey, we also did this CST is owned by my IRA, but it paid me too, okay? All right, if you think about this, why not allow that? Well, because then people would just take all their money, form a company, pay all their money to the company, and have the company pay them, and then not pay taxes on anything. On January 1st, 2006, they entered into an agreement to lease this property, okay? Oh, so now they're leasing. CST is going to lease DJ's property. CST used this real estate to operate a used car business. Okay, we saw that just a minute ago. Throughout this tax year, rent payments were made, and then, okay, so we're getting the idea what's going on here. Boom, boom, boom. We got all this stuff going on here. And then it continues, and we're going to get into a lot of other things, okay, that I don't believe we need to go through each one of these slides, explain, but the money's going back and forth between, he's just running a business, trying to do his own thing, but the government just harassing him. Okay? All right. Now, okay, respondent, which is the IRS in this story. Petitioner is Terry because they got assessed the tax. They're petitioning the court saying, I should not have to pay this. So the IRS gets to respond. Determination. In the notice of deficiency were based on the premise that at one of the few alternative points during the tax year of 2005 and 2006, Mr. Ellis engaged in a prohibited transaction. Under what section? The section we've been talking about earlier today with his IRA. Okay. Say, hey, this was prohibited. It was disqualified. It was disqualified. They couldn't do this. Respondent further determined on the first day of the taxable year in which the prohibited transaction occurred, Mr. Ellis' IRA ceased to be eligible retirement plan. Okay. They just said, hey, now it's not a retirement plan. We're not going to throw you in jail, but you got to pay. So I went through, okay, here's the rule that the court puts out. Okay, you cannot engage in the sale and exchange of membership interest in CST in a taxable year when Mr. Ellis caused CST, an entity owned by his IRA, to pay him compensation. That also violated the rule. When Mr. Ellis caused CST, an entity owned by his IRA, to pay him compensation in 2006, it violated the rule. And when Mr. Ellis caused CST, an entity owned by his IRA, to enter into a lease agreement. Can't enter into lease agreements also with CDJ, an entity owned by both petitioner and his children. They're all, it's disqualified. Even if it was just his kids, it would be disqualified. They're disqualified people. Okay? We have the rule here. We have our prohibited transactions. Okay? We have the rule laid out even further. You can't do any direct or indirect transactions with any of these things. We've gone over these rules. Now the court's laying out the rules. These are the rules. So we have our facts. And when you're doing law, we put the rules in, and then the next is going to be the analysis of this. And then we're going to have a conclusion. All right. Oh, here's some more thing. Okay. Also, one of the best things is what's the purpose of this? Okay, the purpose of 4975 is to prevent taxpayers involved in qualified retirement plans from using the plan to engage in transactions for their own account that could place the plan's asset and income at risk of loss before retirement. Yeah, we don't want people investing their own money in themselves. We want it in the stock market because The stock market is better at not losing their money than they are themselves, right? That's why my dad said he invested in the stock market for 20 years, and when he went to take it out, he counted it all up and he had less money in there than before, because that's what they wanted. Okay? The enumerated transactions set forth in section 4975 are meant to exhibit per se examples of this kind of self-dealing. It's not exclusive to that. There could be more things. We're just trying to tell you what's prohibited. Don't engage in business with yourself, your family, or other people that might not be the best. Okay, the fiduciary is defined as any person who, exercises any discretionary authority or discretionary control. All right, so a fiduciary, who are fiduciaries? Okay, these people who oversee things, they render investment advice for a fee, your financial advisor, okay, your attorney. These people would be your fiduciary, so we want to make sure we don't include them. All right, let's apply this rule. Okay, so now the court's going to go through and go, let's see, did Mr. Ellis violate these rules? Mr. Ellis certainly exercised discretionary control over his IRA and likewise exercised control over disposition of assets. Of course he was the one in charge of everything. Mr. Ellis seeded his plan in June of 2005 with the proceeds from section of his Section 401k plan account from his 401k. So he took his money from the account, put it in there. Okay, Mr. Ellis then exercised control over his IRAs, causing him to engage in the purchase of membership in CST. So he took that money, put it into a company that he controlled and he ran. Accordingly, Mr. Ellis was the fiduciary of his own IRA, so he was the one doing all this. Okay. As previously stated, okay, we have our rule here. Okay, you can't do this. You can't take your money. You can't put. We have our disqualified person rule. You can't engage in business with your own business. But wait. Swanson versus Commissioner. Petitioner argued that Mr. Ellis did not engage in a prohibited transaction by causing his IRA to invest into CST. And he relies on this law. Taylor, you told me at the beginning of this. Wait. You told me I could take my money and invest it in my own LLC. But that looks like they're saying you can't do this. Okay. Now let's go through. In Swanson, the Swanson case is the one that allowed this type of investing to happen, to create the IRA LLC. In Swanson, the taxpayer organized a domestic, don't worry about what he organized. He organized a business, okay? The taxpayer then established an IRA, okay? Same thing, looks the same, and subsequently execute subscription agreements for exchange for IRA. Okay, so we use membership units because it's an LLC, but in corporations you have shares, so it sold the shares, same thing. That's what they did. Of course, a corporation without shares or shareholders does not fit the definition of a disqualified person. There was no prohibited transaction because this company did not have anybody in it. It just bought the shares from it, invested in that LLC, which is totally allowed under the law. That is not the problem. The problem is the prohibited transactions that later happen. The court finds in this context that an LLC that elects to be treated as a corporation and does not have members or membership interests is sufficiently analogous to a corporation without shares or shareholders. Mr. Ellis organized CST without taking any ownership interest in the company. Okay? In the original operating agreement dated May 25th, 2005, Mr. Ellis' IRA is shown as an investing member with 98% ownership in CST in exchange for the initial capital contribution of $319,500. Mr. Ellis' IRA was subsequently created in June 7th of 2005. The initial capital contribution was effected through the transfer of funds to CST in the payment of $254,000 and $65,500 on June 23rd and August 23rd, respectively. The end result of this transaction was the creation of a new entity, CST, and with Mr. Ellis' IRA as founding member with a 98% ownership interest. CST had no outstanding owners or ownership interest before the initial capital contribution and therefore could not be a disqualified person at the time of the investment by Mr. Ellis' IRA. So, if you go on the internet, you will read a lot of people that will say, well, it was the second contribution that caused one of the problems. No, they're not saying that. They're saying right there, and we don't care if you made two different contributions. Initially, the initial funding, the $319,000. Now, let's say this he had just said, oh well, $254,000, and so in this initial thing, he said, oh, my capitalization is only going to be $250,000, and then later on put another $65,000. That would have created a problem. But because he just paid at two different times, the court said, fine, we're not going to consider that. It is not a disqualified person. Okay. He did not engage in a prohibited transaction. All right, we're good. Good. You can do this. It's allowed. You just read it in court. This is a tax court. Went to district court, federal district court. They all agreed. You can do this. And this is a sub-note, though, from the case. And sub-notes are always important. Respondent has also argued that Mr. Ellis engaged in a prohibited transaction when he caused his IRA to invest in CST because the investment was made as part of an arrangement whereby it was expected that a prohibited transaction would later occur. In light of the following analysis, the court finds it unnecessary to address this argument at this time. What if you're planning on doing something, but then you don't do it? Can the IRS come after you? I don't know. They left it open there. So make sure when you set this up, you talk to an attorney, make sure you're doing it right. Compensation. All righty. Okay. So now it goes through. You can't direct or indirectly, you can't do a prohibited transaction. As you know, Mr. Ellis was a fiduciary of his IRA and therefore a disqualified person. He cannot contract business. Okay. He can't get paid. Okay. Mr. Ellis was the sole individual in whose benefit the IRA was established and therefore the beneficial owner of 98% of the outstanding membership in CST. Okay. Because Mr. A fiduciary of his IRA was the beneficial shareholder of more than 50% of the outstanding shares interest in CST. Notice we said that. Well, what if he was 49%? Well, technically might have been okay. Well, we have to get into whether 10% compensation to a highly compensated employee. CST met the definition of a disqualified person. Okay. He owns more than 50%. Now it is a disqualified person to compensate him, not to form it. It's a key thing you got to get in your brain. Okay, so the compensation was the problem. Him paying himself, not forming the company. If he would have taken the money and invested it in something else, he would have been just fine. Okay, and then it goes through, he's a disqualified person because personal benefit. During the tax year, he got paid compensation and he reported it on his corporate tax return. The general manager shall be entitled to such guarantee payment as approved by the member. So it said in the operating agreement that CST could get paid. The general manager could. So when they formed this company, that was that sub-note. It was intended they were going to engage in this behavior. It is unclear whether Mr. Ellis was issued compensation under this guaranteed payment provision or as wages. We don't know. However, as a fiduciary of his own IRA, a member of CST with 90% ownership, outstanding ownership interest, and the general manager of CST, Mr. Ellis ultimately had discretionary authority to determine the amount of his compensation and affect its issuance in either circumstances. So he's disqualified. Okay? Prohibited transaction, investing in personal business. Petitioner argues that Mr. Ellis did not engage in a prohibited when he caused this. So this is good. So this is going to be Mr. Ellis. I need to get a drink. I'm losing my voice here. Mr. Ellis is saying, okay, so he's going to counter the argument. And let's listen to what he says. When he caused CST to pay him compensation because the amount it paid to him did not consist of planned income or assets of his IRA, but merely the income or assets of the company in which the IRA had invested. So the $9,000, that was probably to do the sale of some cars. So he sold some cars. I didn't take my IRA money to pay me. I took the money from me selling cars. So let's see. Oh, you never like to see it, the word however, when you put an argument forward to a court. CST was funded almost exclusively by the assets of Mr. Ellis's IRA. Furthermore, the assets of Mr. Ellis's IRA consist only of its members' ownership interest in CST, valued at $319,480. Okay, and the $1,778 in cash. To say that CST was merely a company in which Mr. Ellis' IRA invested is completely mischaracterization, when in reality CST and Mr. Ellis's IRA are substantially the same entity. It's the same thing. In causing CST to pay him compensation, Mr. Ellis engaged in the transfer of planned income or assets for his own benefit in violation of Section 4975C1D. Furthermore, in authorizing and effecting this transfer, Mr. Ellis dealt with income or assets of his IRA for his own interest and for his own account in violation of this section. Okay? Can't do it. And that's a good argument. I mean, this is a really good argument. Say, hey, so I work for a company and they go out and they do business and I make money. I can't pay myself. Yeah, that's what it's saying. You can't do that. Ellis objection under 4975. So he objects again. Petitioner also argues. Exempts the payment of compensation by CST to Mr. Ellis in tax year 2005 from being classified as a prohibited transaction. Okay, so we have this 4975 D10. That section provides that the prohibited transaction set forth under that section, okay, shall not apply to receipts by a disqualified person for any reasonable compensation for services rendered. Well, that seems to be what happened here. Or for the reimbursement of expenses properly and accurately incurred in the performance of his duties with the plan. It seems to be what happened, but how does the court get around this then? Oh, whoa. They said, oh, there's a different. Oh, investment management agreement. Oh, they go, that rule applies to something else. The amount CST paid as compensation to Mr. Ellis were not for services provided in the administration of a qualified retirement plan in managing its investments. So you have to understand that rule applies to specifically a certain thing, okay? All right? Accordingly, Section 4975 D10 does not apply. All right? So whoever was encouraging him to do this didn't explain this. I imagine what happened, someone read the rule and read part of the rule, didn't read the whole rule, and didn't understand that applied to fees and compensation paid pursuant to a plan's investment management agreement, but not other compensation from companies in which the plan is invested. Alrighty. Conclusion. In essence, Mr. Ellis formulated a plan in which he would use his retirement savings as a startup capital for a used car business. That's exactly what he was doing. Mr. Ellis would operate this business and use it as his primary source of income by paying himself compensation for his role in his day-to-day operation. Mr. Ellis effected this plan by establishing the used car business as an investment of his IRA, attempting to preserve the integrity of the IRA as a qualified retirement plan. However, this is precisely the kind of self-dealing that Section 4975 was enacted to prohibit. For the foregoing reasons, the court sustained respondent's determination that Mr. Ellis engaged in prohibited transactions under the Sec 4975 when he caused CST to pay him compensation. Okay? Now, as you saw, there's a lot of things going on, and I could have got a little bit further into this, but I'm going to stop here on this because I think you get the point. This IRA LLC is not designed to do a startup. The Robs might be, but this you cannot. This actually has to be an investment. You have to be looking to go invest in something else, and you're not going to benefit. You're not going to pay yourself anything. And if you're going to do this, you are responsible. Mr. Ellis just didn't get the proper advice. Someone should have sat him down and been like, hey, you can't start a used business like this. You're going to find a different way to pull this off. All right? So, can you do IRAs, LLCs? Yes. You need to be careful. Yes. Be careful on how you do it, but an IRA, LLC is completely legal under the law as long as you follow the three major rules. Let's go back up to the very top. You can't do a prohibited transaction with a disqualified person. Prohibited to do personally benefit, or the disqualified person is prohibited from personally benefiting. And we have prohibited investments. Other than that, go ahead, enjoy yourself. invest your money outside of the IRA because it's going to be doomed. The stock market is going to tank. And then there'll be good times to go pick up the scraps because of the hyperinflation we'll have afterwards.